And joining us now with more on this is constitutional attorney Andrew Lieb. Andrew, thank you so much for joining us here to kind of break this down for our viewers. Now, the Supreme Court saying that this concealed carry law here in New York violates the Second Amendment at this point. So this isn't a new law. We know that it's a century old, basically limiting who can carry a handgun. Mixed reaction to this, right? A lot of people saying this hurts efforts to prevent gun violence, but others saying it can protect people, it protects our constitutional rights. So moving forward here in New York, now that this law has been shot down by the Supreme Court, what does this mean for gun owners and people who are looking to own a gun? What does it change?
There are 7 states, including New York, that didn't have a shall issue law, meaning that the default was in New York under what's called the Sullivan Act from 1911, that you had to show a particularized risk of safety to get a gun. Now we're joining the 43 states that have shall issue laws because, as the Supreme Court said, a handgun is a quintessential self-defense weapon. And so what they're saying moving forward is, in New York, unless we're in what's called a sensitive place based on history, people are going to be able to have their handguns in concealed carry anywhere throughout the state.
So you don't need to have this specific permit anymore. How difficult was that for people to get in the past? And now you're saying it'll just be a whole lot easier?
That's precisely what I'm saying. Previously, you had to say, I have what's called a particularized risk for safety. I can show me myself have this risk. Now they're called a shall issue. I want it, I get it. And what the court did, which was so interesting in this case, is they said states like New York can no longer argue that they have regulations for legitimate interests, like you were saying in that past package with Governor Hochul, that we need to protect our safety. Now the only way a state like New York could restrict guns is, they say, historically sensitive places, and they give 3 examples of polling places, having the assembly or courthouses, through analogy, would be a sensitive place that we could restrict guns. Otherwise, states like New York are out of luck.
Well, we have a lot to cover with this issue, this decision just being made by the Supreme Court today. So, Andrew, thanks for your time on this. We here at News 12 will be following this, of course, throughout the day. But, Andrew, thanks for clarifying that for our viewers in the meantime. We appreciate it.
Thank you.